Well, it's been nearly 4.5 years since the massacre at Sandy Hook Elementary School in Newtown, Connecticut. And for many, the search for justice, it is still ongoing. The gunman that day, he killed himself, so there is no one to prosecute criminally. But what about the people who not only made the guns, but sold the guns that were used that fateful day? Federal law prevents gun makers from being held liable for crimes committed with their products. But that protection may not exist on the state level. So, 10 families of Sandy Hook victims, they are suing in state court. The suits, they are aimed at the AR-15 semi-automatic rifle, which was used in this massacre. And the families, they're suing the gun's manufacturer, the distributor, and the store that sold the weapon. Now, a group of emergency room doctors from Sandy Hook, from Columbine, from San Bernardino, and Aurora, they're trying to get involved. They have submitted a brief in the case detailing the damage that these kinds of semi-automatic weapons can do. Earlier today, I spoke with Danbury Hospital emergency room physician Dr. William Begg, who treated some of the victims at Sandy Hook, and attorney Michael Dell. A lot to unpack here, but before we get into the case itself and the amicus brief, Doctor, take us back, unfortunately, to that day. You were in the emergency room. You were hoping to try and treat victims. Unfortunately, there were no survivors, as we already know. Take us back to, because you have a human connection to this too. Beyond being a physician, obviously, you have children in the town, and this hit very close to home.
Yeah, well, thank you for the opportunity to speak. So taken back to that horrific day, that was a day where children in our town went to school and thought they were going to come home. And on that Friday morning, we unexpectedly received a phone call from EMS that there had been a shooting. We knew it was at a school, but we didn't understand the gravity right away. As it turned out, most of the children did not come in to the emergency department. In fact, only a few did. And the reason why is because of the horrific injuries that they sustained at the scene from the assault weapon. That day is particularly troubling because the resuscitation teams were made up of a significant number of Newtown residents, and many of us had children in the schools. In fact, one even lost a child who was part of the resuscitation team. And so I do think this has weighed on all of us, not only in Newtown, but in our country, and I think that's why we need to do a better job as American citizens.
You and other physicians have put your names to this brief. I've spoken since that tragedy to some law enforcement who were there on the scene. I've spoken to the governor who was on the scene. And when they talk about it, beyond the broad issue, they have said on and off camera, you had to see what it looked like to understand it wasn't just the loss of life, but just the carnage. And for people who don't know, an AR-15, which was used here, it's not like the movies. You described just the brutality of what that weapon can and did do. And if you can, for our audience, explain why it's not just the tragedy of it, but, and we'll get into not just the weapon, but those that produced the weapon, et cetera, but what that weapon can do.
The reason why there's a disproportionate number of deaths from assault weapons, more than 50% of the people who are shot will die, is because of the horrific nature of the injuries. These weapons were designed for military purposes. They were not designed for hunting or for sportsmanship or self-protection. And what the bullet does, it essentially explodes inside the body and obliterates the organs. The coroner report from the state of Connecticut reported that each child had 3 to 11 bullets, and there was no chance of survivability. That's why none of the victims came into the emergency department. This was made for military purposes, and it's my opinion, the opinion of medical personnel, that it should not be in our American society.
Michael, explain to the audience what negligent entrustment means.
Well, negligent entrustment is, in the context of these weapons, is giving out these weapons in a way that you know will cause a foreseeable injury. And here, the makers and the sellers of these weapons know exactly what these weapons can be used for. And what they have already been used for in multiple occasions, in mass killings, mass shootings. As Dr. Begg was saying, these weapons were made for military use. They can shoot enormous numbers of bullets in a very short period of time. The devastation at Sandy Hook was all within 5 minutes. Enormous numbers of bullets, completely destroying the bodies of these children. So entrusting these weapons to the public, to ordinary civilians, when you know that this can happen, that we believe should be included within the concept of negligent entrustment, and there should be a cause of action, and the makers and sellers of these weapons should have to be accountable.
And they cited clearly the unique immunity that the gun industry has right now. How do you get around that, which seems to say that at the end of the day, they can put out a gun, even the argument would follow an assault weapon, and say, we just produced the thing, we're not responsible for how it's used, by whom, and what they do with it.
There is a unique immunity that unfortunately Congress has created for makers and sellers of these guns. But that immunity does provide that there's an exception for negligent entrustment. And negligent entrustment is defined within the statute. And there's also a cause of action for negligent entrustment in most states, and there is in Connecticut. And so the real question here, and the question that the lower court wrestled with, and now the Supreme Court of Connecticut will address, is does this fall within that, within the ambit of the negligent entrustment as defined in the federal statute?
As we mentioned, Doctor, this is not, sadly, a single incident we talk about. And the letters, in addition to yourself, that the other doctors have signed, they come from Colorado, obviously the site of Columbine, and other points. At the end of the day, obviously your job is to preserve life, but you believe this argument obviously should begin far before they come into your emergency room.
Absolutely. The medical profession has traditionally been reactive. When someone is shot, we think about what are the best techniques to help them survive. But the reality is, despite all the research that we can do for medical treatment, most are not going to survive. So I believe it's the role of physicians and medical personnel to be proactive. It is predictable. We know that there will be hundreds of more mass shootings in our country, and people will die unless we make some changes as a result of assault weapons.
In fact, the governor said this to me, he goes, you know, for all the people who argue that this is an overreach, it's not only a protected right to own a gun here, but slippery slope, and all the arguments we've all heard and I'm sure participated in the past. If they saw those children, I guarantee you minds would be changed. Obviously, you can't do that, but my point is, at the end of the day, do you really believe that you can clear that hurdle of the immunity they have? I know you've laid out the legal argument for it. What are the chances that this really, granted at the highest court in Connecticut, can actually move forward?
Well, I think the court should do it, and one of the reasons I think that these physicians have stepped forward, and the physicians who treated victims of Aurora, San Bernardino, Columbine, and many other victims of these weapons. And I think the reason they stepped forward was to distinguish these weapons and the injuries they cause from ordinary guns. Some of these physicians are gun owners. They're not. This is not a brief or a lawsuit that's asking to eliminate guns or eliminate the Second Amendment. This is simply saying that for these sorts of guns, which are for military use and which cause enormous havoc and aren't needed for hunting and aren't needed for self-defense, there should be different treatment. And I think I'm hopeful that the Supreme Court of Connecticut will recognize that.
I'm actually even more confident, because if I look at from the perspective of being a public health issue, and I look at what's happened to public health issues of tobacco use and motor vehicle related issues, it was a generational change, and we had incremental successes. So I can tell you with confidence, when we look back in a number of years, we will be successful on this front and with this public health issue. There's no doubt in my mind.
Well, we've talked about this program many times. The public polling is overwhelmingly in support of your side, but the power of the lobbying organizations and the influence that they have on Capitol Hill has been something that we haven't seen really broken through on. We'll see what happens in this case. But gentlemen, I really appreciate the time, and I wish you the best of luck.
Thank you very much.
Thank you. And up next, everyone knows golf can be an expensive sport, especially when it's the Donald playing, and the American people are picking up the tab. Trump being Trump means some big travel bills here for you and also me here, the taxpayer. We will detail and discuss as he gets ready to hit the links yet again.